The Ninth Circuit Court of Appeals just made a move in Miller versus Bonta that nobody saw coming, and what happens in the next 90 days could determine whether California's 35-year-old assault weapon ban survives or crumbles into constitutional dust. This isn't just another court filing that legal nerds argue about on Twitter. This is a case that affects over 39 million Californians and sets the blueprint for gun laws in 9 Western states. If you own firearms, if you care about constitutional rights, or if you just want to understand how power actually works in America, you need to hear what I'm about to tell you. Hit that subscribe button right now, because the legal earthquake that's about to hit is something the mainstream media is completely missing. And by the time they figure it out, the entire landscape of gun rights in America will have already shifted. The Ninth Circuit has scheduled oral arguments in Miller versus Bonta for the first time since the Supreme Court dropped its Bruin decision back in June 2022. For over 2.5 years, this case has been stuck in legal purgatory while courts across the country tried to figure out what Bruin actually means for existing gun laws. Now, suddenly, the Ninth Circuit is moving at warp speed. The 3-judge panel assigned to this case has ordered both sides to submit supplemental briefs addressing one critical question. How does California's assault weapon ban comply with the new constitutional standard established in Bruin? And here's what makes this absolutely explosive. The panel isn't asking if the ban complies. They're asking how. That single word tells you everything about where this case is headed. For 18 months, this case was buried in legal limbo while the courts played a game of constitutional chess. But the silence just ended. A series of breaking developments, including a critical move by the Ninth Circuit following the controversial Duncan en banc decision, has put Miller versus Bonta on a collision course with the Supreme Court. This is the front line of a war for the Second Amendment. If Miller falls, the assault weapon as a legal category could die with it. But if the Ninth Circuit gets its way, your right to own the most popular rifle in America could be reinterpreted into extinction. California's Attorney General Rob Bonta now has to defend a law that was written in 1989, signed by Governor George Deukmejian, and based on federal legislation that has since expired. This ban was created in a completely different constitutional universe, back when courts used a balancing test that heavily favored government restrictions. Those rules don't exist anymore. The Supreme Court threw them in the garbage with Bruin. And now California has to prove something that might be legally impossible, that banning the most popular rifle platform in America aligns with firearm regulations from the founding era. Let me put this in perspective. There are currently over 24 million AR-15 style rifles in civilian hands across the United States. That's not a guess. That's data from the National Shooting Sports Foundation based on manufacturing and import records. To put that number in context, there are approximately 25 million Honda Civics on American roads. That's more than the number of Ford F-150s. It's more than the population of most states. When 1 in every 13 Americans own something, calling it unusual becomes a constitutional problem. To understand why Miller versus Bonta matters so much, you need to understand what the Supreme Court actually did in Bruin. Before June 2022, courts evaluated gun laws using something called means-end scrutiny. Basically, judges would ask, is this gun restriction reasonably related to an important government interest like public safety? If the answer was yes, the law usually survived. Under that framework, California won almost every single challenge to its gun laws. Courts would defer to legislative judgments about what makes communities safer. Expert testimony about crime statistics mattered. Studies about gun violence carried weight. Justice Clarence Thomas took that entire approach and set it on fire. Writing for a 6-justice majority in Bruin, Thomas declared that courts can no longer balance Second Amendment rights against government interests. There's no more weighing costs and benefits, no more deference to legislative wisdom, no more debating whether a restriction makes people safer. Instead, there's only one question that matters. Is this restriction consistent with the nation's historical tradition of firearm regulation? If the government can't point to laws from the founding era, roughly 1791, or from the Reconstruction period, roughly 1868, that are genuinely analogous to the modern restriction, the law fails. Period. No exceptions, no balancing, just history and text. This is a constitutional earthquake that has judges across America scrambling to rewrite decades of gun law precedent. Now here's why this creates an impossible problem for California. In 1791, when the Second Amendment was ratified, the most advanced firearms available were flintlock muskets. A well-trained soldier could fire maybe 3 rounds per minute if conditions were perfect. There were no semi-automatic rifles, no detachable magazines holding 30 rounds, no pistol grips or flash suppressors or collapsible stocks. The entire concept of an assault weapon didn't exist until the mid-20th century. So, how does California prove that banning AR-15 style rifles in 2025 aligns with firearm regulations from 1791? They can't point to a founding-era law that banned AR-15s, because AR-15s wouldn't be invented for another 170 years. This is where California's lawyers have to get creative, and their creativity is about to be tested in ways that could expose fatal flaws in their entire legal theory. California's legal team is trying to argue by historical analogy. Since there were no AR-15s in 1791, they're pointing to other laws that restricted certain types of dangerous weapons. Their supplemental briefs cite three main categories of historical precedent. First, they point to 19th century laws that banned Bowie knives and other weapons deemed unusually dangerous. Several states and cities prohibited these large fighting knives in the 1800s, arguing they were tools of violence rather than legitimate self-defense. But here's the catastrophic problem. Those 19th century knife bans? Many of them got struck down by state courts as unconstitutional. In 1871, the Texas Supreme Court invalidated a Bowie knife ban in a case called English versus State, holding that arms in common use for lawful purposes cannot be prohibited. The Arkansas Supreme Court reached a similar conclusion. So California is literally citing overturned laws as historical support for their position. They're pointing to restrictions that other courts already determined violated the right to keep and bear arms. The plaintiffs in their new briefs highlighted this brilliantly. By citing overturned laws, California isn't proving a tradition of regulation. They're proving a tradition of unconstitutional overreach. California's second argument about military weapons being restricted to militia use runs headfirst into actual historical evidence from the founding era, and this evidence is devastating to their case. When the Constitution was ratified, private citizens owned the same firearms that military forces used. There was no distinction between military-grade weapons and civilian weapons because they were the same guns, but it goes even further than that. Private citizens during the founding era owned weapons that were far more powerful than standard infantry arms. They owned cannons. They owned warships equipped with dozens of artillery pieces. The entire American Revolution was fought with privately owned firearms. Militiamen showed up to Lexington and Concord with their own rifles, their own powder, their own shot. The Second Amendment wasn't written to ensure people could own hunting rifles. It was written to ensure citizens could own military-capable arms that would allow them to resist tyranny if necessary. The Supreme Court already settled this debate in District of Columbia versus Heller back in 2008. Justice Antonin Scalia, writing for the majority, explicitly addressed the military weapons question. He wrote that the Second Amendment protects arms in common use for lawful purposes, and he specifically stated that weapons particularly suited for militia service are at the core of the Second Amendment's protection. They're not outside the amendment's scope, they're at the center of it. AR-15 style rifles are based on the M16 and M4 platforms used by the United States military. Under the Supreme Court's own framework articulated in Heller, that makes them more protected, not less protected. The plaintiffs have filed briefs that quote Scalia's language directly, arguing that California's position contradicts binding Supreme Court precedent. But California knows their historical arguments are weak, so they've pivoted to a different strategy, one that relies on 5 words from the Heller decision: dangerous and unusual. In Heller, Justice Scalia wrote that the Second Amendment does not protect weapons that are both dangerous and unusual. This phrase has become California's lifeline, the one piece of Supreme Court language they can cling to while their other arguments sink. California argues that AR-15 style rifles meet this test. They claim these firearms are dangerous because they're disproportionately used in mass shootings and possess features that make them unusually lethal compared to other firearms. If this argument succeeds, it creates a constitutional escape hatch that could swallow the entire Second Amendment. Here's the problem with calling AR-15s unusually dangerous. According to FBI uniform crime reports, rifles of all types, including AR-15s, hunting rifles, bolt-action rifles, everything, account for fewer than 500 homicides per year in the United States. Some years it's closer to 300. To put that in context, more than 1,700 people are killed with knives each year. More than 600 people are killed with hands, fists, and feet. Blunt objects like hammers and clubs kill more people annually than all rifles combined. The plaintiffs presented data in their 2026 briefings showing that rifles are used in less than 3% of firearm homicides. More people are killed with personal weapons than with all rifles combined. If AR-15 style rifles are unusually dangerous, then virtually every object in America qualifies for that label. The unusual prong fails even more spectacularly. There are over 24 million modern sporting rifles in civilian hands across America. AR-15 style rifles represent approximately 20% of all firearms sold in recent years. They are the most popular centerfire rifle platform in the country. Calling something owned by roughly 1 in 13 Americans unusual requires redefining the English language. But California has a response, and it reveals the absurdity of their entire approach. They argue that something can be common and still unusual in a constitutional sense if it possesses features that distinguish it from traditional firearms. This is where we need to talk about how California's assault weapon ban actually works, because the mechanism of this law reveals just how arbitrary and incoherent it really is. California's assault weapon ban doesn't prohibit firearms based on how they function. It prohibits them based on cosmetic and ergonomic features. A semi-automatic rifle with a detachable magazine is perfectly legal to own in California. But if that exact same rifle has a pistol grip, banned. If it has a flash suppressor, banned. If it has a folding or telescoping stock, banned. Here's what makes this legally problematic. Two functionally identical rifles, firing the same ammunition at the same rate with the same magazine capacity, can have completely different legal statuses based solely on whether one has a pistol grip. The banned rifle and the legal rifle are the same gun. They fire the same bullets at the same velocity with the same accuracy. The only difference is ergonomics and aesthetics. One looks scarier. That's it. The plaintiffs submitted evidence showing two rifles side by side. One is a California-compliant rifle that looks like a traditional hunting gun but fires the same bullet at the same speed with the same magazine. The other is a scary AR-15. California doesn't actually ban the AR-15's engine. It doesn't ban the caliber, the rate of fire, or the magazine capacity. Instead, it bans the skin. A pistol grip doesn't make a rifle more lethal. It affects ergonomics and shooter comfort, but it doesn't increase the bullet's velocity or change the gun's rate of fire. A flash suppressor doesn't make bullets more dangerous. A collapsible stock doesn't increase firepower. It allows the rifle to fit shooters of different sizes, the same way an adjustable car seat accommodates different drivers. The state is arguing that a pistol grip makes a rifle so unusually dangerous that it loses constitutional protection. But as the plaintiffs pointed out, a pistol grip is an ergonomic feature designed for better control and safety. By banning features that make a gun easier to use safely, California is essentially arguing that the Second Amendment only protects guns that are harder to handle. The district court found this logic bordering on the frivolous, yet the Ninth Circuit is currently entertaining it as a way to uphold the ban. Here's where California's strategy truly hits a wall. If they can ban features that make guns more effective, more comfortable, or more adaptable, there's no logical stopping point. They could ban any technological improvement developed after 1791. They could prohibit rifles with rifling because smoothbore muskets were the founding era standard. And this creates a constitutional puzzle that could single-handedly decide Miller versus Bonta. When do you measure whether a weapon is in common use? California banned AR-15 style rifles in 1989. At that time, these firearms were significantly less popular than they are today, but California's ban itself may have prevented these rifles from becoming even more common within California's borders. The state essentially locked AR-15 ownership at 1989 levels while the rest of America continued purchasing them freely. So now California wants to point to the relative scarcity of these rifles within California as evidence that they're unusual. They want to use their own ban as proof that the ban should continue. Can a state create the very condition it then uses to justify a restriction? This is constitutional bootstrapping at its most obvious. The plaintiffs' response in their January 2026 filings was devastating. A state cannot ban a right and then use the success of that ban to justify its existence. If California could do this, they could ban books today and, in 20 years, claim that because nobody reads them, the tradition of reading has ended. The Supreme Court already addressed this in McDonald versus City of Chicago. The court made clear that constitutional guarantees have the same scope and meaning everywhere in the United States. The Second Amendment means the same thing in New York as it does in Texas. States don't get to redefine constitutional rights based on their own political preferences. If the Second Amendment has uniform meaning across all 50 states, then California cannot define common use differently than the rest of the nation. The state cannot argue that AR-15s are unusual in California because California banned them, while simultaneously acknowledging that 24 million of these rifles exist elsewhere in America. To understand the tension inside the Ninth Circuit right now, you need to know about what happened in Duncan vs. Bonta because it's the blueprint the Ninth Circuit is trying to use to kill Miller. In December 2025, the Ninth Circuit took the magazine ban case en banc. In a move that Judge Lawrence Van Dyke called terribly unprincipled, the majority ruled that magazines are not arms, but merely accessories. By stripping magazines of their status as arms, the court claimed they didn't even have to follow the Second Amendment. The Ninth Circuit is now trying to apply this component theory to the AR-15. They're arguing that if they can't ban the rifle, they can ban the features, the pistol grips, and the collapsible stocks by calling them non-essential accessories. It's a backdoor attempt to bypass the Supreme Court. But here's where the legal landscape just shifted dramatically. On January 2, 2026, a 3-judge panel dropped a massive ruling in Baird versus Bonta, declaring California's ban on open carry unconstitutional. The judge who wrote that scorched earth opinion was Judge Lawrence Van Dyke. In his ruling, he didn't just strike down the law, he called out the state of California for using subterfuge to deny citizens their rights. This is the energy currently vibrating through the halls of the Ninth Circuit as Miller reaches its boiling point. The 3-judge panel now tasked with Miller includes Judge Kenneth Lee and Judge Lawrence Van Dyke. The pro-Second Amendment wing of the court is done playing games. They're applying the Bruin test with surgical precision, and they're finding that California's history is empty of any legitimate analogs. California wants courts to weigh the government's interest in preventing mass shootings against the Second Amendment right to own AR-15 style rifles. There's one enormous problem. The Supreme Court explicitly forbade it. Justice Clarence Thomas was crystal clear in Bruin. Courts cannot engage in means-end scrutiny for Second Amendment cases. They cannot balance the strength of the government's interest against the importance of the constitutional right. The Second Amendment is not a second-class right subject to different standards. It receives the same rigorous protection as freedom of speech and freedom of religion. Courts don't balance free speech rights against the government's interest in preventing harmful speech. Constitutional rights operate as trumps over policy preferences, except in the narrowest circumstances defined by historical tradition. This means California cannot win by proving that assault weapon bans reduce gun deaths, even if they could definitively prove that claim. The constitutional analysis doesn't include a step where courts evaluate whether the restriction is good policy or effective. The only question under Bruin is whether the restriction aligns with the nation's historical tradition of firearm regulation. If the Ninth Circuit strikes down California's assault weapon ban, the decision will immediately affect 9 western states. Millions of Americans in California, Oregon, Washington, and Hawaii will potentially gain access to firearms that have been banned for decades. Other states with similar bans will face immediate legal challenges. We could see a domino effect where assault weapon bans fall across the entire country. The oral arguments are scheduled for the coming months. The Ninth Circuit typically issues decisions within 6 to 9 months after oral argument. Whichever side loses will almost certainly petition the Supreme Court for review. The justices have already shown they're willing to take Second Amendment cases and reshape this area of law. Miller versus Bonta could be headed to the Supreme Court, where the same 6-justice majority that decided Bruin will have the final word. The Ninth Circuit's move on Miller versus Bonta is the beginning of the end for the assault weapon as a legal concept. The state is out of history, out of logic, and following the Baird decision, it seems they're running out of friendly judges. California's strategy of delay and pray is failing. This isn't just about a rifle. It's about whether a state can relabel your constitutional rights into a crime. The Ninth Circuit could drop this decision any day now. When it happens, the internet is going to melt down. If you want to stay ahead of this story and understand exactly how it impacts your constitutional rights, subscribe and smash that notification bell right now. I'll be covering every development in this case as it happens. Drop a comment below with your prediction. Does California's assault weapon ban survive, or does the Ninth Circuit strike it down? And explain your reasoning. I want to hear what you think happens next. The constitutional earthquake is coming. Make sure you're not caught off guard when it hits.